Good afternoon, everyone. I think people are still joining.
Yeah,
Vishnu, I
yeah.
think we can start. We can
Yeah,
start. It's 3 o'clock.
definitely. And also in the true data protection spirit, we don't want to collect anything over and above on our data of the people, right? So let me begin with, before we start with one of my personal experience we just had last week, right? So I was in Ahmedabad and for some work and was taking the early morning flight. As a convenience, obviously all of us do this, try to book the Uber. But this time instead of booking the Uber, I was trying to reserve it. And those who have tried this, while reserving, you can do it for a later time. So while doing so, it asked me where you want to go. So I just put the drop location as Ahmedabad airport. And the moment I did, it also asked me which airline you're traveling with. I selected Air India. And to my surprise, it showed the all the flights from 4 a.m. till going 8 a.m. And I selected the applicable flight to me. That was 6:45 a.m. And automation at its smartness, right? It automatically calculates the traveling time, also the standard time we should be at the airport, that is 2 hours, and it displayed the time at which I should leave the hotel, that is 4:15 a.m. I was a little surprised, right? It was so smart to have and convenience that everything system did. I had nothing to do with it. I just selected the time and I did the booking. I was pretty impressed by the intelligence the system was showing until I realized what just happened. So in the flow, what I did, I shared all the irrelevant data technically to Uber as well. My flight detail, my location, which flight I travel with, my behavior, morning flight, all this information is passed on to the Uber. And while I was just probably grasping this, processing this, and having the conversation with one of my colleague who was with me, I also threw the question to him, which phone is better, Apple or Android? He just smiled and stayed, which probably this question is again, most of us must have encountered some or the other point in time. But he gave me a very answer which stayed with me. He said that any phone you believe is secured is only for your man ki shanti, nothing more. Funny line, but painful truth, right? Every day we share, generate memo data on every device we use. Data that is procured, stored, analyzed, and often shared with our consent, without our consent. As a businesses or individual, we don't even know what's happening in the background. We know only the front end part of it. And that's why today's conversation is more crucial. I believe the DPDP Act isn't just another regulation. It's about shift in how we view and handle the digital trust, specifically in the today's era where privacy is not a luxury but a necessity. So we definitely need to deep dive in. In today's session, what we're going to learn is what the act is all about, why it is needed now, whom does it apply to, and the most relevant question for all of us, how the businesses, whether in fintech, insurance, healthcare, manufacturing, or any other concern, can comply with this without compromising the processes, businesses, as well as the user experience. That's the most important aspect. To do this, we have with us Rashmi Deshpande. She's a seasoned legal expert with over 2 decades of experience. She's also a managing partner and founder at Legal. She has been forefront in advising businesses on regulatory compliances, privacy laws, and corporate litigation, playing a pivotal role and helping the organization navigating India's complex, fast evolving legal and data protection landscape. She has worked closely with corporate cross sectors, ranging from fintech, healthcare, or any other digital platforms, guiding them through intricacies the Indian legal compliance in the digital age. So, without any further delay, let me call upon Rashmi to deep dive into DPDPA. Over to you, Rashmi.
Thank you so much, Vishnu, for the lovely introductions. And good afternoon, everybody. And thank you so much for joining us on a Friday afternoon for our webinar related to data privacy. Can we move on to the first slide, please? Now, the example which Vishnu had given was absolutely relevant, and this example would have given an idea as to what exactly the DPDP law is addressing. What is the law meant for, and what are the obligations? We have talked a lot about the Act. In fact, in the beginning of the year, there were rules, draft rules, which were open for stakeholder conversations and everything else. And there's a good possibility that the DPDP Act will be operational by the end of this year. But one needs to understand that what exactly does this law address? And why do we have the law now? Why are we talking about it right now? So the genesis lies in many of the points. One of the fundamental being the Puttaswamy judgment, largely known as the Aadhaar judgment, which was pronounced by the Supreme Court in 2017. And in that judgment, for the first time, the Supreme Court basically recognized that the right to privacy is actually a fundamental right of every citizen in India. And this right of privacy has to be maintained and safeguarded by bringing in proper rules and regulations in such a way that even the government and all the agencies which are dealing in a private information of any individual have to adhere to. At the same time, there have been privacy regulations in many countries. You must have heard of the GDPR regulations in Europe. You must have heard about a lot of states in the US coming up with data privacy regulations. Japan was one of the foremost countries which introduced the data privacy regulations. Singapore is also well entrenched in their data privacy regulations. So there should not be any hesitation on the part of any of the MNCs or businesses which are originating in the country to do business in India just because we do not have proper data privacy regulations. And that is also one of the reasons why the data privacy regulation has become so crucial. The act was passed by the parliament in 2023. It's called the DPDP Act, Digital Privacy Data Protection Act 2023. And like I said, the rules also, the draft rules were also out and they will be finalized in a matter of a month or two. And there's a good possibility that the act will actually come in by the end of the year or maybe by next year. Next slide, please. Now, the act addresses the issues related to the personal data of an individual. This act is not about the data of companies, be it the financial data, any other confidential data. It is not related to that. This act is basically related to any personal information which is on the systems of any company, which is also in the system of the government. Anybody who is collecting personal information will have to adhere by the rules and regulations of data privacy framework. Now, when we are talking about personal information, the understanding of personal information under the DPDP Act is very wide. And personal information is anything which basically identifies a person. For example, if there is my phone number or if there is my email ID, which traces back to me, that becomes my personal information. It could be sensitive personal information, it could be normal personal information, but everything that is termed as personal information will be governed by the DPDP Act. All the businesses in any form or the other cover or collect personal information. You collect personal information related to your customers. You collect personal information which is related to your employees. You collect information related to your vendors. So everything that is in your system, which is in the digital format, will be governed by the DPDP Act. Next slide, please. We also want you to understand some of the key concepts under this act. Data principle. Data principle is an individual whose data is collected for the purposes of processing, be it storage, be it anything. When you collect the information of any individual, that individual is termed as data principle under the DPDP Act. Second is data fiduciary. Data fiduciary can be an individual, it can be a legal entity also. Data fiduciary is the one which is collecting the personal information of a data principal for the purposes of processing. Data fiduciaries are the businesses, it is also the government, and maybe the individuals also who are collecting the data information, personal information for commercial purposes. The next important concept is consent. Consent, in fact, is the cornerstone basis which the data principle framework has been brought into existence. Whenever a personal information of any data principle is collected by a data fiduciary, there has to be a valid consent to collect and process this information. This valid consent is basically collected via a notice. A notice should have some of the following ingredients: the reason for which the information is being collected, the purpose for which the information is collected, what is the nature of the information that is going to be collected, the grievance redressal mechanism in case the information that has been collected and the data principle has certain grievances related to the information being collected. There has to be a proper mechanism for such resolution of disputes. Next is the purpose limitation. You have to only collect the information for the purpose of which you have taken consent from the data principle. You cannot, like Vishnu's good example, if you have collected the information for one purpose, you cannot use it for any other purposes. And we will give examples as and when we see how various industries collect and use the information. And lastly is the significant data fiduciary. Now, everybody who collects personal information is termed as data fiduciary. But there are certain organizations or there are certain uh, sectors who would be collecting information at a very large scale or who might be having an exposure which could be much more than a normal data fiduciary. The government may term such sectors or such organizations as significant data fiduciary. These significant data fiduciaries will have more obligations compared to a normal data fiduciary. More obligations includes that they have to hire a DPO, data processing officer, and they may have to undertake an audit of their systems on a yearly basis. Next slide, please. Now, once you have understood the key concepts, the businesses, it's very relevant for them to understand what are the obligations that they have to follow under the DPDP Act. Like I said, there has to be a notice. A notice has to be given in a very clear language. It is also the requirement that the notice has to be given in the regional language if required. And the notice cannot be full of legal jargons. It has to be given and worded in such a way that everybody understands what are the contents of the notice. Valid consent. It is the burden of the data fiduciary to prove that a particular information was taken under a valid consent. Purpose and storage limitation. The purpose for which the particular information was taken. Storage. Now, what the DPDP Act says is that as soon as the purpose for which a particular personal information was collected, when the purpose is over, the information has to be deleted from the system. But the Act also says that there are certain sectors, for example, banking sector or healthcare sector, who might have different set of laws and they might have to retain the information for a particular amount of years, particular number of months. In that case, the DPTP says that you have to oblige by the sector-wise information. The data principle rights. The data principle has been given a lot of rights. One of the primary rights is that whatever information has been shared with the data fiduciary, the data principle should have the access to that information. The other thing is that They also should have the right to correct the information, amend the information whenever they want. The other right is right to nominate. Now, this is a very unique right which is not there in any other regulations of other countries. In case if there is a death of the data principal, or if for any reason the data principal is incapacitated, the data principal has the right to nominate another person who will be able to exercise the rights given under the DPDP Act vis-a-vis the personal data of the data principal. And lastly, like I said, there has to be a grievance redressal mechanism for any kind of grievance that data principal feels with respect to his information. Next slide, please. Now, what we have done is that we have identified certain sectors where implications of data privacy regulations could be an issue, could have certain problems, and what these sectors should look out for before the Data Privacy Act becomes operational. Now, let's get into startups. Now, startups could be of any scale. There could be 2 employees, 1 employee, or the startup could be a unicorn also. But the obligations under the Data Privacy Act have to be followed by the startups when they start collecting personal information in a digital format. There are certain exceptions with respect to consent notice obligation, but still majority of obligations is something that the startups will have to follow. And one is very mindful of the fact that when it comes to startups, the founders have to take into consideration the expense which will be generated by bringing in the necessary tweaks in the systems. So founders have to be mindful that before they start their business, costing in terms of data privacy adherence has to be taken in mind. Next slide, please. The other sector that we are looking at is the healthcare sector. The unique thing about the healthcare sector is that it not only collects the personal information, but it also collects what can be termed as a sensitive personal information. And although under the DPDP Act, there is no difference between personal information and what is sensitive personal information, there is a possibility that the government might term the healthcare sector as a significant data fiduciaries, and they may have to adhere to certain more obligations than a normal DPDP, than a normal data fiduciary. Now, the thing with healthcare sector is that they have an exposure to a lot more third parties. In a sense, you have doctors and you have nurses and you have the employees of a particular hospital, but a hospital also takes the services of, let's say, an insurance sector. It also takes the services of, let's say, who is providing you cloud services, software services. All these third parties have access to the sensitive personal information of the patients. The penalty under the DPDP Act for violation of the Data Privacy Act is as high as 250 crores. When you consider the penalty amounts, you also understand that there is an obligation on the part of the hospital itself. So, in case if there is any kind of violation, even by the third-party service providers to the hospital will be pulled up and will be liable in front of the Data Privacy Board. Therefore, the third-party obligations, the third-party contracts, agreements are very important at this stage. Perhaps a healthcare sector can also make a representation to the government saying that bring in a concept of joint liability. We move on to the next sector. The next sector is what we call the digital lending or the NBFC sector. Now, what are digital lending platforms? These are platforms which basically provide loans for amounts which are as low as 1,000 to 1 lakh rupees. The unique issue with this particular sector is that there are sector guidelines also which take care or which provide you guidance as to how to provide the data. But where do DPDP guidelines come in and where do you have to adhere to the sector guidelines is very important to understand. I will explain with an example. Let's say there is a person who comes on one of these platforms and he registers himself. When he registered, he has given perhaps his name and also maybe his email ID or for that matter, his mobile number. Now he browses through the entire platform and then he realizes that he does not want to take up any of the products. But the information is still stored by the particular platform. And the digital lending guidelines, which have been recently announced by the RBI, they adhere to the regulatory entities which are regulated by the central bank. These regulated entities cater to people who have taken loan, who have become borrowers. There are certain regulations that the digital lending platforms will have to follow in terms of such borrowers, which is there, which is a sector specific deadline, which is a sector specific obligation. But what about the fact who have not gone ahead and taken any sort of a loan or any sort of a product? Do they follow the sector specific deadline or guidelines, or do they follow guidelines which are given under the DPDP Act or for that matter Information Technology Act? This has to be minutely examined by digital lending platforms. And similar issues can also come for the banking sectors. Let's move on to the next slide. In the next slide, we are addressing the insurance companies and insurance brokers. Of course, like the medical sector, insurance sector also has a lot of exposure to third party. And there is a sensitive information also which is being collected by insurance companies. Now, the issue is, in fact, there could be a lot of issues that one might face at the time of implementation in terms of third-party service provider. But specific issues could also come from things like, let's say, information which has been collected and stored, but the policy has lapsed. There are insurance companies who rely on the information that they have received from these lapsed policies and use this information, let's say, for marketing purposes or automated processing purposes where they indulge into customer profiling. Now, if you have not collected the consent for using the personal information for these kind of activities, then you will find yourself in violation of the DPDP Act. The other sector that we have examined is the manpower leasing companies. Next slide, please. What are manpower leasing companies? Manpower leasing companies are the ones who actually hire certain employees on their payroll and lease out the employees to the other companies. There is an exception under the DPDP Act. This exception says that if there is any information which has been collected under the employer-employee relationship, in that case, the consent is not always required. So you see, the manpower leasing companies have become the employers of certain employees, but in order to lease these employees to a third party, they are also sharing the personal information of these employees. At that point of time, the employer-employee relationship might not save such transfer from the leasing companies to the service recipient of such manpower leasing companies. So a back-to-back consent or how the consent mechanism will work is very important to look into for this kind of sector. So there are a lot of issues that we have seen, and we haven't even started scratching the surface when it comes to issues related to many of the sectors. But for the time being, we will restrict ourselves to these sectors and these issues. Next slide, please. Yeah. So there are some very basic things that the companies might do, and this is very much required even before the law is made operational. Uh, in order to make your company or make your systems ready for the DPDP Act, perhaps companies can look and review their privacy policies. Privacy policies is something that every company has. Include clauses in your privacy policies to make your data principals understand how the data collected from principals is safeguarded. There are audits, third party tools which can be put into place. Third party agreements have to be re-looked into. The collection of valid consent is very important. And there is one peculiar thing that whatever personal information that you have already collected, even before the act became operational, once the act is operational, the valid consent will have to be again obtained for such information that organizations already have. And finally, what companies can do is that they should do the exercise of mapping from where personal information is being collected. For instance, people visit the websites of the companies. Those websites are collecting cookies. Now, the cookies are also termed as personal information. There are certain people who visit your offices and you collect information in terms of their names and mobile numbers only for the purposes of visiting the office. What happens to that personal information? So, all the businesses should start mapping where the data is coming from and how it is being used and safeguarded. And I think these are some of the basic things that businesses should already start doing and not wait for the act to become operational. So, with that, I finish my PPT and I understand there are a lot of questions that we have received from the audiences. So, over to you, Vishnu. We can start the Q&A session also.
Thanks, Lakshmi, for the insightful information. It was definitely helpful. I believe people and business have to follow it to ensure Jamtara activity does not continue anymore, right?
Yes.
So we have received a lot of questions. What we have done in backend is that we have collated them for ease of reference for all the audience, so that their questions are also, answered here. So we'll ask few of them. After that, also, if any of the person feels that question is not answered, then definitely you can ask them.
Yeah, I mean, there is a lot we can say about the DPDP Act. 1 hour is absolutely no time to pack in all the information.
Definitely. So, in fact, whenever the new regulation comes, it's very difficult to have a summary in half an hour, 1 hour's time. You need more longer sessions for that. But
Correct.
this is definitely a first one. We'll have more to follow up on this. So, one question, rather, I would say first question. As per you, how does the DPDP Act differs from global privacy laws like GDPR? Is it broadly aligned in terms of the principles, or it uniquely Indian consideration that businesses should be mindful of?
So India's DPDP Act, of course, we unfortunately have been one of the last few countries who have started the process of adopting the Data Privacy Act, but the principles remain the same. World over, the data privacy acts and regulations are safeguarding the personal information of individuals, which of course our act is also doing. What our act is also doing is that at this stage, it is much more simpler compared to perhaps the GDPR, because GDPR was made operational in 2018 and it has evolved over the years. So, yes, there is a lot of literature when it comes to GDPR, but the act, the DPDP India's act has been simplified because the government is very mindful of the fact, Vishnu, that we did not have something like a DPDP earlier. Now, I remember when the GST was brought in, we already had VAT and we already had service tax. Now, of course, there were a lot of changes at that point of time, but the infrastructure was already there. When you're talking about an Individual Privacy Data Act, the mindsets have to be changed of the people, and they should be able to provide a thorough respect to their own individual information, which unfortunately in India is missing. And most importantly, the businesses should understand that when it comes to the individual information, it has to be sacrosanct, and all the safeguards have to be put in place so that the information is not misplaced, not hacked. So, in principle, we are very much aligned with the GDPR and the other developed country acts, but we have also made it simpler, at least at the beginning, and we will see how it evolves over the years.
Perfect. I think that answers part of it. Second question again, from your experience, what are the most common blind spot businesses have when it comes to data collection, storage, or consent? Also for the mid-sized businesses, which backbone or pillar of the Indian economy, MSME, with limited tech resources, how should they start preparing for compliance? Any quick wins or low-hanging fruits they can act on today?
Hmm. Uh, I've pretty much taken care of this question in my last slide, but again, I would like to emphasize on some of the points. See, uh, everybody keeps on asking me that, Data Privacy Act was passed by the Parliament in 2023, and we are sitting in the middle of 2025. Still, there is no sign of it being implemented. But one has to keep in mind that the act is very much there, and there has been a lot of activities from mighty from the government, like they came up with the data privacy rules January this year. They have been making noises about finalizing these rules maybe in a month or so. All the businesses, maybe mid-size startups or everybody, they have to start preparing. And when I say start preparing, at least start mapping the data. The example which I gave, now nobody would have thought that, if you have a website and your website is also collecting cookies, the cookies are also termed as personal data. You have to get into your systems and understand what all are the avenues from which the data are being collected. Now, let's be mindful of the fact that we are talking about digital data. If you're collecting data on a piece of paper and storing it the way it is, you don't have to adhere by any of the obligations under the Data Privacy Act. But if you're collecting that information and converting it into a digital format, you have to adhere to the data principal obligations. What you need to do is perhaps look into your agreements also with third parties, because it may just so happen that you will put in place all your systems, but there could be weaknesses in the third party system. And if you're sharing the personal information that you are collecting with your third party, then also you're exposing yourself to a lot of liability. So start understanding the system, do a sort of a data audit if it is possible, look into all the agreements and the contracts that you have, and prepare yourself for the act. I think that is the basic. And if this exercise is done at this level, there will not be much that will be required once the act is operational.
Perfect. I think precaution is better than cure.
Yeah.
Another, although it is covered in the slide part of it, but still there are a couple of questions, so I thought we'll ask that as well. Specifically with regard to insurance and fintech industries, which has more data collection points. What make these industries particularly more vulnerable as compared to any other industries in terms of data privacy risk? And what are the specific practices they should immediately revisit?
I think that's a very good question, because a lot of fintech industries also that we are helping, they also come up with all these kind of questions, and there are queries which are coming on an everyday basis. the biggest issue with fintech industry is that they collect the data for one purpose and they use it for multiple purposes. That's a clear violation. Now, there are notices that are sent, and the DPDP says that the notices have to be sent keeping in mind the specific purpose for which you are collecting it. You have to, every time you use a particular data for anything for which you have not received the valid consent, you have to be mindful that you will be required to collect consent. It may just so happen that you collect it for let's say for a bank. The bank is collecting the data in order to understand whether you're a good candidate for the purposes of giving loans or not, disbursing loans or not. Once the loan is disbursed to you, the data is still lying with the bank. Now, the systems should be able to identify that this data has been collected only for these purposes. And the system should not allow the particular data to be used for any other manner, for marketing purposes, or let's say for AI analysis purposes, because there is, customer profiling that also happens at the back end. That's also a clear violation. So identify what you're collecting the data for, make provisions in the system that the data should only be collected and kept for this particular purpose. And then in case if the purpose changes, make sure that the valid notices are given and the consent is collected. So an entire system will have to change to ensure that these obligations are looked at. And fintech sector, given the kind of data that they are collecting, there's a financial information that is being collected by the fintech sector, which is sensitive information. There is a good possibility that they will be termed as the significant data fiduciary. So they have to be mindful of this fact as well.
That's right. Taking that sector itself, healthcare or manpower outsourcing, where the personal data flows across the parties, multiple parties rather, I would say. How should such industries manage this consent or restrict access and implement data minimization in such complex environment where systems are mapping systems and they're running systems?
See, consent, like I said, is the cornerstone of the Data Privacy Act. And the example that we spoke about for, let's say, the Manpower leasing companies. Now, on one hand, you're collecting the consent. Let's say you're recruiting a particular employee as an employee of the Manpower leasing company, and you are transferring his personal information to probably your service recipients. Now, you perhaps may not be required to take the consent because you are going under the exception of the employee-employee relationship. But you have not taken the consent to transfer the data to a third party. In fact, there is another angle which should be visited, and I see there could be a lot of confusion prevailing under this particular concept and might lead to certain litigation, is that how much can you stretch the employer-employee relationship also? Because that is one concept which has not been defined. So if you're able, you will have to establish that whatever processing that you are doing on the data of your employees, even if you are sending it to a third party, that has to come within the definition, or rather the understanding of an employee-employer relationship. Now, the manpower leasing companies will have to make provisions that when you are transferring the personal data of your employee to somebody else, get a consent from your employee. Now, how will you get the consent? Now, there are really practical issues in a sense. Let's say you are on the payroll of a manpower leasing company, and there are 5 companies to whom the manpower leasing company is sharing the CV of a particular employee. Now, the issue is, how many people are you supposed to tell them the name of the companies with whom the CVs are being shared, in what capacity is being shared? all these questions have to be taken into consideration when you develop your consent mechanism. Because again and again, I keep on saying that the valid consent, the burden of proving that a particular consent is valid and correct is always on the data fiduciary. So yes, a lot of tweaking of the systems will have to be taken care of.
So you all rose down to consent again.
Yeah, it's the cornerstone. It's the cornerstone of the data privacy regulations.
So what role do consent manager play under the current data protection framework? And how do they impact or facilitate cross-border data transfers?
Now, consent manager also, I think this is a terminology which is not actually mentioned under many of the data privacy regulations of the other countries. And it is very well something which the Indian laws have come up with. Now, the consent manager has a very major role to play. And part of the obligations of the consent manager were also defined under the DPDP rules that were issued in January of this year. The consent manager is the one who basically is the repository of all the data, personal data, but you have to be mindful that he, as a consent manager, does not have access to the data. A consent manager will ensure that a valid consent is taken and stored with him every time there is a change in the nature of specific obligations, every time there is new data which has to be collected. So the role of a consent manager is very, very important. Every company will have to align itself with a consent manager. The consent manager has a lot of obligations to follow. They are also one of the parties which are liable to the data privacy board. And at the same time, a consent manager also has an obligation to the data principal. So we will see perhaps a lot of companies coming up with this new products. There will be companies which will come up with data consent manager services. They will have to have valid licenses. They will have to have fulfill obligations under the DPDP rules and regulations. And their role will be very important in the entire framework of data privacy. And their liability will be also as much as the liability of a particular data fiduciary. So yes, consent manager is a very novel concept. There are a lot of liabilities and there are a lot of obligations riding on his head. But I personally feel that when you have introduced the concept of consent manager, the entire framework has become more professional and the systems have become robust. So I will be very curious to see how the consent manager mechanism plays out once the act is made operational, and how much of their liability they carry well, and how much of their requirement or how much they are used by the companies and the data privacy board to ensure a proper implementation. So it's a very interesting thing to look forward to.
Right. You spoke about data fiduciary, I mean, the role that it plays, right?
Sorry, I forgot that you had also asked a question regarding cross-border data transfer.
That's right.
Yeah. So let me answer that also. When the act was included, so the act said that whenever there is a transfer of data, cross-border transfer of data, there will be rules and regulations which the central government will come up with. When the draft rules were introduced, at that point of time, the draft rules have strictly said that whoever will be termed as significant data fiduciary may not be allowed to transfer or store their data outside India. Now, these are draft rules, of course, and from what I understand, there has been a lot of representation which has been received by the ministry, particularly on this point. So right now, if you talk about the cross-border transfer, I would say the act is playing it very safe, but only when the rules are finalized and when we have more notifications coming in, we will get to know as to where we stand in terms of transferring the data outside India. But right now, only if you go by the act, there aren't any major restrictions, so to say. So let's see what the rules have to say, because this is a concept lot of MNCs are grappling with, because they have their perhaps excellence center outside India. There are a lot of MNCs where the systems are monitored by the HOs from outside India. So the data flow goes outside India, the data flows outside India very easily. If we have really strict rules and regulations where the data will have to be maintained in India, the MNCs will also face probably a significant expenditure and perhaps a change in their systems to ensure that we abide by this requirement. So, yes, this is a very major issue, largely being debated at the ministry level, and there is a lot of hesitation to have major restrictions on the data flow. So let's see what the rules have been finalized and what they say.
That's correct. From data fiduciary perspective, do you believe they have to follow different processes to safeguard themselves?
Uh, yeah, in a sense, when you're talking about obligations, all the obligations are for a data fiduciary. They have to put in place proper systems. They also, in case if there is any breach in their systems, there is a very short time limit within which they also have to go ahead and let the data privacy board know. And more importantly, if there is any breach in their system with respect to information of certain data principles, they will have to inform the data principles also. They are obligated to the data privacy board. Grievance redressal mechanism is very important. I mean, in a sense, whenever a notice is sent out for the purposes of collecting the data, the notice itself should have the path to the grievance redressal mechanism. So, lot of obligations for the data fiduciaries to follow, and lot more for significant data fiduciaries to follow. So yes, in fact, the act is worded in such a way that there are a lot of rights given to the data principals and there are a lot of obligations of the data fiduciary. So yes,
Makes
a lot
sense.
of work for businesses who are collecting personal information.
So one, rather I would say, sector-specific question which has been asked by few people
Yeah, sure.
is with regard to crypto. I think hot topic. So couple of questions on them. I'll ask both of them so that you can answer them together. How will the implementation of the act impact the operation of crypto exchanges in India? That's the first question we have. I mean, summary. Second, what are the key data privacy challenges and regulatory considerations for the crypto industry, specifically in the light of evolving global and India's legal framework?
So let me just answer your second question first. We do not have robust regulations when we are talking about cryptocurrencies. And it has been an endeavor not only of my organization, but lot of other, in fact, the industry itself is making representations to the government that it is high time now that we should have crypto regulations. There are crypto regulations in almost all developed countries, be it the US with their federal laws, MICA in Europe, you have VARA perhaps in UAE, and there are regulations in Singapore also. So the crypto industry, obviously, for them to operate, there has to be set of rules and regulations. But when we are talking about data privacy in terms of the crypto companies, of course, the DPDP Act is taking care of those requirements also. When we are talking about cryptos, it started off as something which was protecting the privacy of a particular individual, whoever had cryptos, and but this was very initial. Now, when you have intermediaries, and when I'm talking about intermediaries, they are platforms from which the cryptos are bought, platforms on which cryptos are traded, sold, etc. The platforms are nothing but data fiduciaries, which are collecting the information of individuals. So they also, as data fiduciaries, will have to go by the obligations meant under the DPDP framework. There is nothing specific for, or there is no requirement to have something specific for the crypto industry, because the DPDP Act in itself is taking care of the privacy aspect. So they will also have to work around their systems. They will have to worry about the storage. They will have to worry about the consent. They will have to worry about the data minimization. They will have to worry about the redressal mechanism that they are able to put on their systems. So everything which any other data fiduciary is required to do, every crypto player which is collecting personal information, be it a platform or any sort of intermediary, will come under the garb of DPDP Act.
Okay.
Yeah.
Maybe last couple of questions we'll ask before I take the audience direct question.
Sure.
One of them is, do you believe that the implementation of the act may have, although not intended, unintended, negative impact on the businesses?
I would not call it a negative impact. In a sense, yes, the systems will have to be overhauled. There would be certain expenses that one will have to deploy in order to make their systems DPDP ready. But in a long term perspective, what is required is again a mindset change. If you are able to give the due respect to anybody's personal information in your system, and this is a long term implementation, I don't think so there will be any sort of a negative impact, so to say. Immediately, there are questions which are coming from firms like which are into marketing. In a sense, you know, let's take a practical scenario that if you want ABC Bank to reach out to you for any new products, they will have to take your consent. And 99.9% of the time, people will not give their consent because nobody wants to receive those pesky calls. How do you move around this requirement? How you are taking care of the marketing aspect and at the same time taking care of the business expansion? It's a very thin line, but DPDP obligations are very clear. They will evolve over the years. Perhaps there would be certain leniency, but long-term impact will not be negative at all. Businesses will evolve. Other countries will start probably trusting Indian businesses more with their personal data. And in general, there will be a sacrosanctity which should be associated with personal information that will come. So, yes, in long term, there is nothing negative. Short term, yes, you have to change your systems. You have to come up with significant expenses. Perhaps you need to have a DPO and relook at the agreements and everything else. This is going to be a short term fallout, but in a long term basis, I think there will be more trust in Indian businesses.
Okay. So last question, probably summary we had. Although you gave a scary number of 250 crore as a final consequences,
I didn't give
that
it's in
maximum
the
could
act.
be, which was sufficient for all of us to be, scared of. But other than that's the maximum penalty we have, and obviously you have to go as a mean. So how punitive you think the act is? Also, do you foresee a grace period and handholding from the regulation? Because this is definitely, as you mentioned earlier as well, a completely new framework we're gonna have. Or should the businesses prepare for strict scrutiny from the day one itself, that is from now itself?
There will be a grace period. And I think your last question was very important because this is what the businesses should know. The government has been talking about grace period. The government will give grace period. There will be a sufficient level of hand holding. In fact, even the stakeholder conversations that are happening, we see a lot of positivity from the government, where the government is ready to understand the nitty-gritties of each business, and they do understand that when you're talking about implementation of a Data Privacy Act, which was not there earlier, and there will be a lot of changes on the part of the businesses to do that. There is a lot of positive, a positive mindset that the government is adopting, and there will be a grace period for businesses to adopt, align their systems, and from day one, if you're in violation, nobody is going to charge you 250 as a penalty. So that's the evolving thing. I think why we have a number as high as 250 is that there is a message which is being sent that we are very serious about the data privacy, we are very serious about the individual privacy, and therefore we have to make sure that people and the businesses take it seriously. We want to give an impression out to the global world that we also take our data privacy regulations extremely seriously. And that is why perhaps the 250 crore number is out. So the businesses should start preparing themselves, and they should prepare themselves with bona fide intentions. It's not going to be that, the government is going to penalize you in the first year or the first few months and everything else.
Right.
But in case if you are knowingly not preparing, then you are in a
Absolutely. And
Yeah.
for being, if you have to bring deterrence, then definitely the penal consequences are on the higher side.
correct.
Low
Absolutely.
penalty, Indians have definitely a mindset that we look at the penalty first, then the compliance. If penalty is on the lower side, we always will be non-compliant and pay the penalty. That probably have
Yeah,
observed in my
absolutely. Absolutely.
interaction specifically, right?
Yeah,
And
but we hope that, it's a simple act. In a sense, there is simplicity in the act. Implementation is going to be an altogether different ball game. But let's start preparing for it now. Let's not wait till the end. And there are a lot of things that businesses can do as of now. And those are simple things, you know. I mean, I'm saying simple. Once you get into the systems, it's going to be an entirely different ball game. There are a lot of complexities. So it's good to identify the complexities at this stage. I mean, whatever one or two issues that we have tried understanding in this particular session, it's like I said, just scratching the surface. There are too many nitty-gritties.
bang on target. I think there are a lot of questions, but as promised at the start of the session, we are neither going to create data for more than an hour, or neither we are going to store for the audience that they are attending the sessions.
Yes.
So what we'll do, we'll collate all these questions, and we'll make a summary of it, and definitely we'll answer all of them. You can access this recording as well on the YouTube. We'll share the link for the participants who have attended there. I think with this, we are sharp on time. Thanks, Ashmi, for the insightful sessions. Hope
Lovely. It was lovely
audience,
talking.
yeah, audience have given the same review. So as we mentioned earlier, it's not sufficient to have this 1 hour session. We'll definitely look forward to have more in detail analysis of this act soon.
Thank you so much, and thank you everybody for joining. I
Yeah.
hope we were able to clear some of the basic concepts.
Thanks,
Thank you.
everyone. Thanks for joining.
Yeah. Good evening.